Okay. Looks like we're ready to receive Mr. Fox's testimony.
Yes, Judge, we are.
Okay, all right.
Thank you.
Go ahead and we'll proceed.
Would you like me to swear him?
Please.
Okay. Mr. Fox, can you hear me?
I can.
Okay, if you could raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Great, thank you. Mr. Fox, I brought you here to testify about a meeting that happened February 17th when you represented Bo Dukes. Do you remember that?
I do.
How did that meeting come about?
That meeting, if I recall correctly, was largely arranged by GDI agent Shadell. He and I had conferred either the Thursday or the Friday prior, confirmed that my client would be willing to meet at the GDI office with representatives from the counties that were impacted, and that was arranged for Sunday morning, February 7th. I believe it was 17th or the 19th.
Okay, and did Agent Shadell arrange for those representatives from the counties to be present?
That is my understanding, yes.
Okay.
I did not confer with them prior.
Okay, so you only spoke with Agent Shadell prior?
That's correct.
Okay. And so tell me about that meeting, what happened at that meeting? First, why don't you tell me who was there first?
Pardon?
Who was there?
Okay. Present at that meeting occurred at the GDI office, the local office in Perry. It was in the morning. Present at that were myself, my client, Mr. Dukes. Also present were the DA from Ocilla, Paul, I apologize, his last name escapes me at the moment, Kim Schwalls, who I believe was a district attorney in that office as Paul was preparing to travel out of town the next week. Mr. Rigby, Brad Rigby from the Cordial Judicial Circuit was there, and then Agent Shadell. There was another agent present, but when the meeting occurred, both of the GDI agents were out in the hallway. They were not in the room.
Okay, and is it Paul Bowden? Is that his last name?
Yes, that's it. My apologies to Paul if he's in the room for getting his last name.
He's not a problem. So the agents, you said the agents left during the beginning of this interview or this meeting?
That's my recollection, yes.
Okay. And what happened when the agents were out of the room? What was discussed?
What was discussed, well, one were the expectations, and sort of loosely why we were there. That was Mr. Dukes had information concerning the disappearance and missing persons case involving Mrs. Grinstead. Law enforcement was interested in that information. And there was a discussion, one, understanding as to why we were there, two, as to the completeness and truthfulness of the information. That is, the expectation was that Mr. Dukes would be absolutely truthful, transparent, and complete with the information that he had, and he agreed to do so. And then the discussion was also that while no specific promises were made as to any particular sentence, any particular charges, that there was the ability of law enforcement. And when I say law enforcement, let me be clear, I'm not talking about GDI agents, I'm talking about Mr. Bowden and the other district attorneys who were present, that they would be in a position to help Mr. Dukes if they were to help them, and that is by providing true, transparent, honest information concerning the disappearance of Tara Grinstead.
And so your client was told that he would have help if he was truthful and forthcoming with his information?
That's correct. Yes, that they were in a position to be able to assist him.
Okay. And based on that, did your client agree to give information based on that representation from the state?
That is my understanding, yes. He agreed that day, provided some basic limited information, and then came back. I'll apologize, I don't recall offhand whether it was the next Monday or Tuesday, but they met at length there at the GDI Perry office and gave a recorded interview.
Okay. So that day, though, that Sunday, he was promised assistance if he was forthcoming with his information.
Objection leading.
I'll hear from you, Ms. Merchant.
I can rephrase it, Judge.
Yeah, I
Thank you.
sustain that.
Thank you. What was your client promised if he was forthcoming with information?
Assistance. There were no specific charges or that would either be brought or not. There was no specific promise as to a sentence, but it was made clear, at least in my opinion, that if he were to assist them, that is the prosecution, they were in a position to assist him.
Okay.
I
And
think the expectation, at least my takeaway, is that both sides expected there to be a quid pro quo.
I understand. And that's what your client understood that.
And that's my understanding, yes.
Was there any discussion of immunity if your client was to testify?
Not during that meeting.
Okay. And was there a conversation about immunity at a subsequent time?
Not at a subsequent time.
Okay. So tell me about the DA's leaving and then Agent Sheldell taking over. How did that transpire?
I recall correctly, after we had a discussion, everyone understood that they were on the same page, at least in terms of the expectation of honesty, providing information, assistance being provided as a result of that. My recollection is the agent or law enforcement went and got Agent Sheldell, had Agent Sheldell come back in and witness Mr. Dukes providing a very basic handwritten, I believe it was a handwritten statement, providing information as to very broadly what had happened to Mrs. Grinstead and those who were involved in it.
Okay. So it was immediately after this this interview with the district attorneys that the interview with Agent Sheldell took place?
Objection reading.
And when I say,
Hang on a second.
let me be clear, the actual
Hang on a second, please. Can you
full interview occurred,
tell him to stop?
they
Mr.
agreed
Fox.
that during
Mr. Fox.
Sunday meeting, there was,
Mr.
I'll say very brief.
Can-
One second, I'm sorry, there's, Ms. Hart objected to the question.
Yeah.
Okay, I'm sorry, I didn't get it.
Yes.
All right.
Okay. What
I
was your-
sustained, it was a leading question.
leading,
Yeah, I sustained that objection.
So tell me about the transition from the meeting with the district attorney.
Attorneys to the meeting with Agent Sheldell.
Sure, after, I don't recall whether literally the parties shook hands, but after the parties had come to, I would say, at least an agreement as to the understanding. That is, Mr. Dukes would be truthful, forthcoming, honest, and if he did so, the prosecution was in a position to be able to provide assistance. Once everyone was on the same page with that, contact information was exchanged. It's my recollection then that Agent Sheldell was brought back into the room where Mr. Dukes and I and district attorneys had been meeting behind closed doors, and then took some very basic information in broad strokes as to what had happened with Ms. Grinstead and who the parties were who were involved in that.
Okay. Thank you. Just one moment. Other than this meeting, was there any other meetings with the district attorney's office?
Not that I recall.
Okay. So you left that meeting. What did you leave that meeting thinking was the agreement?
Well, I left that agreement, and I can't speak for my client, okay? But I left that agreement with the understanding and the impression that if Mr. Dukes were to provide the information that had been requested, that is, providing the information he had, the names of those who were involved, and being truthful about it, that they would then assist him. Again, this assistance was not specified, but it was also very clear, at least in my opinion, that law enforcement, the district attorney's office, recognized the value of the information, provided the value of bringing closure to Mrs. Grinstead's case, and they were most interested in obtaining that information and resolving the matter.
Is that you then went into an interview with your client after that?
That's correct.
Okay. Was that interview based on your decision to do that interview? Was that somehow based on the conversation that you had with the district attorney's office?
In my opinion, it was, yes.
Thank you.
Thank you, Judge. sure exactly where I need to stand for you to see me. There we go. Mr. Fox, how are you today?
I'm well, how are you?
I'm doing well, thank you. I do have a few questions for you. Going back to the meeting that occurred that day, prior to that particular meeting, you had actually been, I don't know if the word retained is correct, but you'd been spoken with about representing the defendant by a lady named Brooke Sheridan, correct?
Correct.
And you knew Brooke personally, is that right?
When you say defendant, you mean Mr. Dukes?
I apologize, yes, your client, Mr. Dukes. Brooke Sheridan is the one who introduced you to Mr. Dukes, correct?
That's correct.
And you understood at the time that this meeting was scheduled that it was scheduled because Bo Dukes had already indicated that he wished to cooperate with law enforcement, correct?
That was not my understanding. My understanding was in talking with, after conferring with Mr. Dukes, conferred with Agent Shadell, who had contacted Mr. Dukes prior. I believe it was after, I may have this wrong, it's been several years after he had obtained, I think, information from Brooke Sheridan. We had talked, indicated he would arrange the meeting. In reviewing my notes, he at that time had indicated that there was some discussion, potentially community, that again was not discussed that Sunday. But my understanding was that after conferring with Mr. Dukes, he wanted to talk to law enforcement. Based on our discussions, not that he had previously promised law enforcement he would sit down with him on Sunday, I believe it was the 19th of 2017.
Okay, so, and perhaps my question was asked poorly, but the entire purpose of that meeting on that Sunday was because Mr. Dukes wanted to speak with law enforcement, correct?
In part, but the purpose of that meeting also was, in my opinion and estimation, in order for those who were involved to be able to meet face to face and determine what arrangements could be made.
Okay. You would agree with me that it was Jason Shadell who suggested that the district attorney's office be present, correct?
I can't speak to that. My understanding in talking with him is that they would be present.
Okay.
Of course, I was fine with that because Agent Shadell, while he has a lot of powers as a GDI officer, certainly can't promise or not promise prosecution. So simply sitting down and talking with Agent Shadell, while that would have been talking with law enforcement, would not have been conversation with one who had the ability, one way or the other, to be able to make or confer any type of benefits.
But you never requested the district attorney's office be there, correct?
No, because I believe Agent Shadell, when we had talked that Friday or Thursday, indicated he would arrange for a meeting with the district attorney's office.
Okay. Now, in that meeting, you would agree with me that there was never any deal offered to your client, correct?
Oh, correct. There was no specific deal offered in terms of what would be charged, what would not be charged, amount of time, length, one way or the other.
Okay. And how long have you been practicing criminal law, sir?
Well, as I sit here now, roughly 20 years.
Okay. You would agree with me that these sorts of interactions related to whether or not someone wants to assist law enforcement are pretty common, correct?
Not in the state system. I would say in the federal system, yes, but unlike the state system, federally we use a proffer letter that explains the exact rights that are actually signed by all parties. So, now, that may just be the nature of my practice, but I don't recall many meetings, such as the one with Mr. Dukes, where the actual district attorneys involved would sit down and meet with the defendant prior to any discussions with law enforcement.
So in your practice, as it relates to the state system in Georgia, this was a novel sort of meeting for you?
I would say under these circumstances, yes.
Okay. You would agree with me that at no point during that meeting did you ask Paul Bowden for any specific promises if if Mr. Dukes spoke with law enforcement, correct?
Well, no, but the reason for that also is Mr. Bowden had not been provided the information. In essence, we'd be asking Mr. Bowden to bid against himself. It went both ways.
Okay.
I would say there was a bit of trust, or at least my estimation is that it was a situation that required a bit of trust on the parties. That is, the state would trust that they were going to be obtaining information that they could then verify that would be truthful. And Mr. Dukes would be trusting that he would see some benefit as a result of providing that information.
So essentially, it was a situation where Mr. Bowden was saying, if Bo Dukes does the right thing, then the state will be in a position to do the right thing as well, correct?
Not in so many words, but the expectation was there was a quid pro quo. That is, one party would do one thing in exchange, another party would.
And you would agree with me in your experience as a criminal attorney that that does not equal a deal, correct?
When you say equal a deal, you mean in terms of an agreed upon binding plea to specific charges or specific sentence?
Yes, sir. I mean a deal under the definition of Georgia law. You would agree with me that does not equal a deal?
That is not a specific deal as to any particular charge or any particular sentence.
Okay. And Mr. Bowden never told you that your client would not be prosecuted in this case, correct?
Not that I recall from this Sunday, no.
And you actually anticipated that he would, in fact, be prosecuted at some point for some offense, correct?
I would say as of that Sunday, it couldn't be ruled out, but I wouldn't say that I had firm expectations one way or the other.
And that's because, again, Paul Bowden never made any specific representations, correct?
Not that I recall.
And you would agree with me that Brad Rigby, District Attorney for the Cordele Judicial Circuit, never made any specific representations about any charges being taken or not taken against Bo Dukes, correct?
No, the only thing I remember Mr. Rigby saying was something to the effect of he was fine going along with whatever Paul Bowden wanted to do, since it was more or less an Oscilla type case, and that he would be willing to go along with it as long as it was something that he just couldn't do.
Okay. And that conversation occurred inside the four walls of the GBI office, correct?
It did? Yes, ma'am, that closed me.
And in fact, your client was prosecuted in Wilcox County, correct?
He was, and he was also indicted in Hill.
That was my next question. To your knowledge, he still has a charges pending against him in Ben Hill County as well, correct?
That's my understanding. Do understand I've withdrawn from representation in that matter, so I can't speak to the status of that case at this point in time.
I think you were released by the judge maybe back in September of last year from the Ben Hill case. Okay. But at the time that you were released as his attorney in Ben Hill County, he still had been indicted in Ben Hill County, correct?
Correct.
And at the time that you were relieved from the case, you had no agreement in place with District Attorney Brad Rigby as to what would happen with the Ben Hill County case, correct?
Oh, no, in fact, it had been indicted, it was being prosecuted, so that was clear what was going to happen.
And at the time that you were relieved as his attorney in the Ben Hill case, you had no agreement with any attorney related to what was going to happen to Bo Dukes and his Ben Hill County charges, correct?
Outside of Brad Rigby, I don't know of any other lawyers who are involved in the case.
And in the Wilcox County case, obviously that case went to trial, correct? Sorry, court reporter, yes?
Oh, I'm sorry, yes.
Okay. And prior to that trial, there was never any agreement in place as it related to your client's charges not going forward, correct?
No, in fact, if I recall correctly, he had been told he could either plead and get the maximum or go to trial.
Okay.
So,
And in fact, he went to trial, correct?
correct.
And after sentencing, Mr. Rigby argued for the court to give him the maximum sentence allowed under law.
Oh, that's correct.
And the judge did that.
That's my understanding.
Now, prior to any evidence being presented in this case, there was a Jackson-Denno hearing related to Bo Dukes' statements being admissible. Is that correct?
That's my understanding.
And at that time, you argued to the court that there was what we refer to as the slightest hope of benefit.
That's correct.
However, again, even in your arguments to the court, you agreed that there was no deal in place at the time that your client made a statement.
Yes, that's correct. statements of the district attorneys created the slightest hope of benefit.
And you would agree with me that that's a different standard for whether or not there's an actual deal in place legally?
I do.
Okay. And obviously you were unsuccessful as it related to that particular Jackson-Denno argument.
Well, the court admitted both statements that were issued.
Thank you. So essentially, if I understand your testimony, it is that at the time that you left that meeting on that Sunday, the only idea that you had was that if your client was cooperative and told the truth, that there was a possibility in the future that he might receive some sort of benefit for that, correct?
Yes, with the exception of the word possibility, because that was not a word that was used that Sunday. What was said that Sunday was, if your client is truthful with us, there will be a benefit to him. Not that there would possibly be a benefit to him. So my expectation when I left that meeting Sunday was that if he did what the state had asked, was transparent, truthful, and honest about what happened to Ms. Grinstead, those who were involved, and providing information that would allow for the case to be prosecuted, he would receive a benefit. And that was my understanding when I left that.
In fact, what Mr. Bowden said was that if he did those things, that he would be in a position to help. Is that correct?
I don't recall that specific,
Okay.
or I don't believe it was in my notes from the meeting that day.
You don't believe it was in your notes from the meeting that day?
That's correct.
So you have notes from the meeting that day?
I have very basic notes as to who was there, yes.
Have those been provided to defense counsel in this case, the Duke case?
Not that I'm aware of, but they've also never been requested.
That was going to be my question, was if they had requested them. Have you had a chance to review those notes prior to today?
Am I?
Yes.
I'm sorry, I didn't hear you.
Sorry.
I had reviewed, yes, I have.
Okay. And again, when it comes down to it, as of today's date, or as of the last time that you represented Bo Dukes, there is no deal in place for him to receive any lighter sentence, correct?
No.
Now, just a moment, Judge. In this particular case, when you got involved, you were aware that Brooke Sheridan had already spoken with law enforcement, correct?
Yes, ma'am.
And you were aware that Brooke Sheridan had already given a statement to law enforcement implicating both Bo Dukes and Ryan Duke in the murder and then destruction of Tara Grinstead's body.
That was my understanding.
And that Brooke had then gone to Bo and told him essentially that he needed to be honest about what happened.
Can't tell you what she may have told me.
Okay. So you're not aware of the fact that Brooke had already gone to Bo and told Bo that she was cooperating with law enforcement when you were hired in this case?
Judge, I object to
She may
relevance.
very well have.
Hang on a second, Mr. Fry.
Objection, relevance?
Judge, specifically it goes to whether or not Mr. Dukes would have given a statement but for this alleged offer of benefit.
That question can be asked, but that's different.
I'm leading up to that question, Judge.
Overrule that objection. Thank you.
My understanding though is that your response is you don't know if Brooke Sheridan had already told Bo he needed to cooperate with law enforcement?
I don't have any recollection of that at this time. But I mean, also understand that this is almost 5 years ago. So.
Oh, I understand. Now, again, it was Brooke that originally contacted you, not Bo, correct?
That's correct.
And at the time that Bo spoke with you, or that Brooke spoke with you, there was already an intention for Bo to speak with law enforcement in some manner, correct?
I can't agree with that.
Okay.
I'm not, yeah.
Is that because you don't know, or because you're saying that's not true?
Well, I'm saying that's not true, but I also cannot go into the specific discussions with my client, given that he's not waiving and I'm not waiving the attorney-client privilege.
I guess let me put it this way then. Is it your testimony here today that but for this quid pro quo, as you put it, that Bo Dukes would not have in fact given a statement to Jason Shadell that day?
Can't speculate to what he may or may not have done under a specific set of circumstances, but I will say this, and that is that meeting was material and essential to his decision to make a statement. If that meeting had never occurred, whether he ultimately would have said something or not, I can't speculate to that. But I know based on what I know in this case, that meeting was material, very material to his decision to speak with law enforcement.
And after that meeting with Mr. Bowden and the other attorneys, Jason Shadell interviewed your client, correct? Or spoke with him?
Mm-hmm.
Is that a yes? Sorry.
Yes, I'm sorry, that's a yes.
Did you take the time to speak with your client privately between Mr. Bowden leaving the room and him talking to Jason Shadell?
I can't tell you whether it was right then, but I know that Mr. Dukes and I conferred at length privately multiple times during that meeting. I believe we may have actually talked certainly prior to him sitting down giving a statement to Agent Shadell.
So you don't recall that Agent Shadell came immediately into the same room that you had been speaking with Mr. Bowden?
I don't, because I remember Mr. Dukes grabbing a cigarette at some point in that.
Okay. And sorry, I had a question that just went completely out of my brain. That happens sometimes. Just a moment. When Mr. Bowden spoke with Bo Dukes, he emphasized that the importance of his statement would be that he be honest and truthful, correct?
That's my recollection.
No further questions at this time.
All right, any follow-up with this motion?
Yes, thank you, Judge.
At some point after Bo gave his statement to Agent Shadell, did he indicate to you that he believed he had a deal in place?
I'm gonna object. That would be hearsay, Judge. At this point, it would not go towards anything that this person did. It would relate specifically to what another person thought, and it would in fact violate his attorney-client privilege as well.
It wouldn't violate his attorney-client privilege because we actually were provided those statements from the state in discovery. So we've got those text messages where Bo was talking about how he thought he had a deal because of what he and Mr. Fox talked about. So Bo's already violated his attorney-client privilege by giving those to the state, and then the state gave them to us. So there's no privilege anymore. We have those statements.
If I am recalling correctly, the text messages she's speaking about are actually between Bo and a gentleman named Dustin Trogdon, and that Dustin Trogdon turned those over to the state. That's not about what he discussed with his attorney. That's about his personal thoughts about it.
Well, that's the statement.
And Judge, I didn't ask him what they discussed. I asked if he had any reason to believe that Bo violated it. And that would be based on this.
That's the statement.
Okay, thank you, Judge. You've reviewed the discovery in the case, I assume that you have.
In Mr. Dukes's case, yes, the discovery from Will Cox and Ben Hill.
Do you remember looking at any text messages that your client sent? Other folks?
Man, I remember going through a lot of text messages were sent.
Do you remember anything where your client indicated that he thought he had a deal?
I remember seeing text messages to that extent.
I just have one other area of questions. The state asked you about whether or not Mr. Dukes believed that he had a benefit to him. Would you, in your representation, would you equate the benefit to some type of leniency?
That's certainly my interpretation, is to a benefit, especially under these circumstances.
Thank you, Mr. Fox. Thank you for being here.
Any further discussion?
Yes, Your Honor. But to be clear, that was something that you were anticipating would happen, not something that was in place, correct?
Yes, but to the extent, well, yes, that is, if your question is, was there a specific benefit promised that day? Leniency is towards a sentence, specific charge? No. Okay, as to something specific. But if the question is, was there a promise as to a benefit? My opinion would be yes, there was. That was my takeaway.
At no point during that meeting did you ever ask Paul Bowden to give your client what we refer to as transactional immunity, correct?
No, I didn't.
At no point during that interview did you ask District Attorney Brad Rigby to give your client transactional immunity.
No, I didn't, but largely because immunity works very differently in the state system than it does in the federal system. And quite frankly, how binding that would be on an office versus the person who makes it remains debatable in my mind. So no, we did not ask for a written immunity agreement.
But you understood that Brad Rigby, who was in the room, was the District Attorney of the Cordell Judicial Circuit, correct?
Mm-hmm. Yes, ma'am.
And you understood that Paul Bowden, who was in the room, was the District Attorney of the Tifton Judicial Circuit, correct?
Correct.
And to your knowledge, those are the only two circuits that were involved in this case, correct?
Based on the information that I had at that time, yes.
And in fact, the information you have at this time is still that those are the only two circuits that were involved in that case, correct?
Correct.
Now, I want to be clear, did you and Mr. Bowden ever discuss whether or not your client would get use and derivative immunity if he testified either at grand jury or at trial?
No, Mr. Bowden and I did not have that discussion.
So you don't recall ever asking Mr. Bowden about that?
I do not recall having that discussion with Mr. Bowden.
No further questions. No further questions.
Thank you for your testimony, Mr. Fox.
Thank you, Mr. Fox. You're excused.
Thank you, Your Honor, and thank you for the accommodation time-wise.
Sure. All right, Lindsay, you can.
He did say he is available Thursday afternoon from 3:30 on if we wanted to take the testimony via Zoom. This Thursday, day after tomorrow. Yes, sir. You had said you weren't available Friday. You asked me about Thursday, and so I asked him that question.
So which, Judge, which dates are you asked? I did not see the email. I apologize. I didn't check my email at lunch.
That's all right. Tuesday afternoon and Wednesday afternoon.
That would be the 15th and the 16th?
Yes.
Okay. I am wide open both days.
Or she has now brought up from Agent Shadell Thursday afternoon via Zoom.
I'd rather do it in person, Judge, because this one I do anticipate having to show documents, which is sometimes difficult via Zoom. So we are available next Tuesday or Thursday, Tuesday or Wednesday at the court's pleasure.
All right.
Just the problem with that is, as Your Honor knows, we've had these scheduled for some time, and the state, Mr. Rigby and I have both made great efforts to be able to be here because frankly, there were 3 other courts that I was needed in today. Next week, I'm also expected to be in jury trials in Wilcox County. We have grand jury on Monday, we begin jury trials on Tuesday. If I am not present, or if Mr. Rigby is not present, and I know that there is a murder case pending on that calendar as well, it completely messes up the other judge's calendar. So we are asking the court to do this on Thursday via Zoom. At this point, although I didn't feel the need to go into this earlier, I would submit to the court that the person at fault for Agent Shadell not being here today is the defense counsel. And so we would ask the court not to have it, not to require us to completely rearrange our schedules when we have gone to great effort to be available today and tomorrow. And we would ask it to be this Thursday in the afternoon. He's going to make himself available. That was what Your Honor asked me, and so
All right.
That's what we would ask.
That's, we'll talk about it finally before we adjourn, and I'll let you know. All right, what else we need to hear at this time? The true or little motion?
Yes, Your Honor, and Your Honor said you do have a copy of my motion for judicial notice that was filed
Yeah.
last Tuesday, I believe.
I do have that, right.
It's
Yes.
my understanding that defense counsel may not be objecting to Your Honor taking judicial notice, and I provided them with the, a paper copy of the order that I had, proposed order I had attached to that email, except I corrected the typo. I understand that they may be in agreement with that, but I'll let them speak to that.
I don't have that order.
I have a
All
copy
right.
of that proposed order, Judge.
Mr. Gibbs, is this yours?
Yes, Your Honor, it is.
Okay.
We have agreed with the state, I guess, to consent to the entry of this proposed order.
Okay, here you go,
The
Mr. Clark.
copy she just handed you. The only thing we did ask is, as we discussed during the recess, some prior versions of the order that we'd circulated earlier in the case had a specific listing of the testing reports that have been done in the case. And so we simply asked the state if they would, verify with us on the record that they, will not submit any additional testing, any additional true or little testing in the case prior to trial. And that if they do so, if that comes up again, then we of course would reserve all objections to admissibility and otherwise.
Of any future testing?
That's right. The testing is sort of in the case, the reports they produced to us so far, if that's sort of the limited universe of the true or little testing, then we will consent to that order with respect to all of that testing that's been done. Anything in the future, though, we would reserve all applicable objections.
And Judge, I guess let me speak. At this point, the state has no intention of any future true or little testing or testing otherwise. I don't state in my place it's not going to happen because crazier things have happened.
That's fine.
However, I will agree that if there is any future true or little testing, that this order would not be binding on any future results.
Sure, I think that's what he said.
That's right. That's right.
All right,
And we'll
do you
agree on
have
that.
an original of this?
That's yours, Judge.
All right, well, let's all sign it. Eight. Hey.
And I guess I should have been prepared by myself.
All right,
Before we move on, just to be clear, we've had the two witnesses here for the Harper hearing since about 10:30, they can leave.
Bacon Lee.
Perfect, thank you, Judge.
All right, let's see, I guess we're swapping over now on this part, down your list. Motion to exclude inadmissible expert testimony.
Yes, Your Honor, and that is actually Mr. Rigby is handling that. He has stepped out for just
That's
a
fine.
moment,
What
apologize.
about motion to exclude inadmissible character?
State's ready for that.
All right, y'all ready?
Yes.
Now, I've read through the brief you filed this morning, I guess. Ms. Merchant, right? Are you ready to, you need some time to go over that?
Your Honor, I would, if it's okay with the court, I did receive it this morning, and obviously it's rather lengthy. What I would like is just to state our position on the record, and then if I can respond to any argument from defense counsel.
All right, go ahead.
Just sort of to fashion what I anticipate the proposed evidence would be. Because there are a couple of different types of evidence.
This is all about Mr. Hughes.
This is all about Bo Dukes, yes, sir.
All right.
Judge, there are charges pending against Mr. Dukes in Houston County, Georgia. There are two separate cases in Houston County pending. The one that occurred first in time was actually indicted second. But in that particular case, there's an allegation that he raped a female at essentially a party that was occurring at Brooke Sheridan's parents' home. That was reported prior to Mr. Dukes being arrested in this case, but it was not indicted at the time. It was not indicted for at least a year later. At some point, while our case here has been pending in Osceola, there has been an outcry.
Approximately what time period is the first instance you're talking about?
Yeah.
That was indicted second.
In February of 2017, about the time that the arrests were being made of this defendant.
And that involved a sole individual.
One individual, and it was a situation of, similar to what we would refer to as a date rape situation. There was a party going on. There's an allegation that he came into her room and raped her in the middle of the night.
Got it.
And that was reported to law enforcement again sometime January, February 2017.
Never resulted in any arrest?
Not until after he was indicted and arrested on a second case in Houston County,
Involving the two?
involving 2 alleged victims, yes, sir.
Okay, all right, go ahead.
So that case, and I apologize, I don't have the dates of that second case in front of me, although I can get it quickly because it's made the news. In that particular case, 2 females have made allegations that the defendant, that Bo Dukes, took them to his home that he shared with Brooke Sheridan, and committed sexual violations. I don't know the exact charges, but that he essentially attacked them, that it was of a sexual nature, and that they had to escape through a bathroom window.
And had a firearm. Is that correct? Was that part of the allegation?
I don't recall specifically because it's not my case.
That was alleged, I think, in Ms. Merchant's brief today, that he
I
allegedly
can find those charges and tell the court for certain what the charges are in Houston County.
In any event, go ahead.
In any event, there was an allegation that he held them hostage at the house, and that they had to escape through the window. He was arrested and charged with that, and those charges are still pending.
Indicted.
He's never been taken to trial on those. He's been indicted, arrested, and I don't recall if a bond had to have been given because I believe he was out on bond when we tried him in Wilcox County. So those are 2 of the situations that we are asking the court not to allow into evidence. The third, and I'm going to refer to it as a situation broadly because it's a situation that is actually, there's no allegation of any crimes being involved. What my understanding is that there is a female who is from Ocilla who has claimed that Mr. Dukes, at some point, the 2 of them engaged in a consensual sexual relationship where he tied her up. I believe that she has claimed that particular event actually took place at the pecan orchard that has been of great discussion in this case. Of course, the evidence in this case will show that Ms. Grinstead her body was not burned in the actual pecan orchard, but that is what everyone believes because that's what they've heard in the media. This particular person, I believe, will indicate that he took her to that pecan orchard and tied her up, but that it was consensual. We are asking the court to exclude all 3 of those from evidence in this case. The first reason is, Judge, we would submit to the court that they're simply not admissible because they're not probative of whether or not this man murdered Tara Grinstead, which is really the whole issue, obviously, of what this case is about. We talk about Bo Dukes a lot, but the truth is this case is about whether or not Ryan Duke murdered Tara Grinstead in Ocilla, Georgia. In the indictment, there are no allegations of false imprisonment. There are no allegations of a sexual violation in any way. And the confession that's been given by the defendant indicated that he broke in there for monetary reasons, not for any sexual nature. And so going into other unproven allegations against Bo Dukes, who is essentially a co-defendant or co-conspirator in this case. They're charged in different counties, but they're charged with acting in concert as it relates to burning her body in Fitchville.
Mr. Duke's not been charged with the murder of Tara Grinstead.
Bo Dukes has never been charged with the murder of Tara Grinstead, nor has he been charged with anything in Irwin County related to Tara Grinstead. He is only charged in Bentonville County with assisting in burning her body and with hiding the fact that that Ryan Duke murdered her. That's also what he's been convicted of, is hiding the fact that Ryan Duke murdered her. And so the state would submit that under our rules of evidence, it's simply not probative and not relevant and should not come in for that reason. And I will tell the court in my motion, I realized last night when I was researching this, that under subsection 2, I put the wrong code section. It's actually 24-608.
Thank you.
And this is obviously assuming that Bo Dukes testifies at a trial. That is an assumption that everyone is making. At this point, there is no, that's up to the state, whether or not we call him, or it's up to the defense if they choose to call him. But the second event will be whether or not it's for impeachment purposes. And so we would ask the court at this point, since although I have filed a motion to keep it out, it's probably untimely at this point because it would only be an issue if he is called to testify in the case. Certainly if he's not called to testify, then it cannot be admitted under 608. I will also point out to the court, I did not argue it in here because we've never received any notice of it. But again, that is exactly my point, is that there's never been any notice of any intent to introduce this under 404B. There is a mechanism under 404B that relates to a non-party. No, there is a provision under 404B where you can get in other bad acts of someone who is not the defendant. But again, there's a certain balancing test that Your Honor would have to do. At this point, we've been given no notice of that. And in fact, all of the information that I've conveyed to the court related to these three different situations has come from the state's case in chief. We've looked into, and obviously Houston County has looked into the Houston County charges. And so we're asking the court at this point to find that they're not relevant and that they're not admissible.
All right, so there's 4 incidents you're talking about, 3 from Houston County, 1 from here.
2 from Houston County, but 3 victims.
That's, 3 different females.
Correct, John.
Right, in Houston County.
Correct.
And the one here has never been charged as a crime.
Well, the one here, my understanding of the allegation is that it was consensual.
Right, that's what I heard you say.
So, yes, sir, it's never been charged. And I guess I'm saying here, her allegation is that it occurred actually in Ben Hill County. I believe there would be evidence that it did not occur in Ben Hill County, it occurred in Wilcox County. But bottom line is we're saying that it's not relevant to whether or not the defendant murdered Tara Grinstead.
Thank you. All right, Ms. Merchant, you disagree, I guess?
Yes, Judge, we disagree. Judge, the rules of evidence in Georgia are rules of inclusion. If Ryan Duke had pending rape charges, you better believe the state would be here seeking to admit those against him. They are definitely probative. Whether or not, if Ryan had taken a woman out to the orchard and tied her up and raped her in the same pecan orchard that it is alleged that parts of this body was found, you better believe the state would be bringing that evidence and saying that it is certainly probative and that any prejudicial value is definitely outweighed by probative. We want the jury to have all of the facts in this case. That's the only way that there can be a valid decision based on the truth and based on what actually happened in this case. And obviously the state wants some of that evidence not to come in front of the jury, but we think that that evidence should come in front of the jury. We think that the jury should hear about, first, let's just talk about Bo's pending charges. Those are always admissible. Pending charges with a testifying witness are always admissible. They are admissible because they could be trying to curry favor with the state by testifying. Whether or not there's a deal in place or not, that's not what the case law requires. The case law requires that the witness has pending charges and that the state is the one that's prosecuting him. It's not this state, it is the state. The state of Georgia is prosecuting him. Doesn't matter if it's this state prosecuting him. So, and we cited this in our brief that we filed, but the case law is very clear that those are admissible. Those types of allegations are admissible, and I'm going to cite you in our motion, let's see, at page 6. There's several different cases. Says that pursuant to the Confrontation Clause of the 6th Amendment, a defendant in a criminal trial is guaranteed the right to cross-examine a witness against him concerning criminal charges brought by the state which are pending against the witness. There are 4 different cases cited there which all hold the exact same thing. This is true regardless of whether the witness has made a formal deal with the prosecution.
So it makes a difference whether the state calls them or you call them, right?
No, it doesn't. Because if you think about it, what matters is his motivation in testifying.
A defendant in a criminal trial, this is what you just cited to me. A defendant in a criminal trial is guaranteed the right to cross-examine a witness against him.
Yes. Bo Dukes is a witness against him, whether we call him or the state calls him. He is the reason that we are here. Ryan would not be sitting here if it wasn't for Bo Dukes. He is definitely a witness against my client. I don't know that that is necessarily in dispute. The state sometimes calls witnesses that don't help them. The defense sometimes calls witnesses that don't help them. Sometimes
But you don't cross-examine the witness that you call.
Not necessarily, but in this case, they use the term cross-examine, definitely.
Right.
But we are entitled to cross-examine adverse witnesses. I would anticipate if Bo Dukes testifies and we have to call him as a witness, I would anticipate getting an order from the court that he's a hostile witness. That is my anticipation. If the state fails to call him as a witness and we are forced to call him as a witness, I truly believe that he will be deemed a hostile witness and we will be able to cross-examine him.
Okay.
And so this will be something that we cross-examine him based on. Maybe they won't. Maybe the state will not put in any of Bo Dukes' statements or statements that Bo made to Brooke or Bo made to Agent Sheldell or Bo made to, the internet. Maybe they won't. And then we wouldn't be getting into this. But if anything Bo says comes in, his credibility is front and central in this case. And the second his credibility comes front and central, we're entitled to bring all of this. The fact that he could want to curry favor with the state doesn't mean that he has a deal in place. He has charges pending in Houston County. He wants those charges to be resolved favorably. Everybody wants that. The law assumes that. And so he would hope that by testifying that those charges would be resolved in a more favorable light. That is the curry favor argument. That is something that is always admissible. And there's two other cases that we can cite. It's error to prohibit the defense from cross-examining an alleged victim with the fact that the victim is facing juvenile delinquency charges. And we go through a very long list of analysis, but ultimately it's whether or not Bo Dukes has bias towards a party, whether or not he wants them to like him more than he wants us to like him. That's as simple as it is. And he has pending charges that the state can put him away for life in prison. Rape carries life in prison. So he would have a motivation that we are entitled to explore on the stand to testify favorably for the state. So we would definitely be able to introduce those just based on that. Not even getting to
That's
the
if
court.
they call him.
No, that's if he's a witness. That's if he's a witness. We're able to impeach our own witnesses. Both sides can impeach their own witnesses. That's the law. There's no law that says
If you're
only if they call.
surprised by their testimony, right, you can impeach them.
We can impeach our own witnesses to take the sting out. We can always impeach our own witnesses, just we call it in slang to take the sting out, but there's ways. And you've got to understand, Judge, this may, if the state doesn't put in a single word spoken by Bo Dukes, then this may not come into play. But they filed.
We wouldn't
this,
be here without that, just like you said.
and I don't know. I don't know what the state plans on introducing. So this may be moot, but the state filed this to keep this out. So I would anticipate, if they're trying to keep us from being able to question Bo about it, that Bo is somehow going to come up in our trial. And if he does come up in our trial, we're entitled then to introduce this. So it could be something that you reserve ruling on until that time comes.
Well, I want to read your brief. I just got it this morning too, so I have not had a chance to study it or read the cases.
Thank you. And we tried very hard. We didn't know because the state didn't identify the specifics. Like I didn't know about this other instance that I didn't know what they were referring to.
Well, your brief brings up this federal case against Mr. Dukes, I guess, yeah, which is apparently not something that you're.
If he testified, it's a federal conviction, he would absolutely could be impeached with that. It's a felony federal conviction. So that would be admissible if he testifies for either side. I agree with that. That's why I've not mentioned it.
Okay. All right. Anything further, Ms. Merchant?
Judge, the other allegation, I don't know that we even know enough specifics on what the state is alleging, why that conduct in the orchard and the pecan orchard wouldn't be admissible, but we would submit that it would be if Bo testifies. Just like if Ryan was accused of doing something like that in the orchard, I'm sure the state would be trying to bring that forward. And so we just want to make sure that the jury has a full picture of what's going on in this case, because this is really a case of who do you believe? And as you've seen through this motion to reveal the deal, you've seen that Bo wanted to get some type of a deal and then immediately rushed to say Ryan did this immediately after that. And showing things that undermine Bo's credibility is very important for a jury to adequately being able to assess who they believe and what they believe happened in this case. And we don't have a notice requirement under 404B. So there is no, I know Ms. Hart mentioned that, I just wanted to throw that out. We don't have a notice requirement, the state does. And so there is no specific notice, but we believe that this is fully admissible regardless.
Let me ask you, for example, the rape charges in Houston County. There's 2 alleged victims there, I understand. You propose to bring those alleged victims down here, I guess, right?
There are 3 victims in that. One of them, unfortunately, is deceased. Okay. But those charges are still pending. So there are different methods that we can get that admitted. The first method is if Mr. Dukes or any of his statements come in, we can impeach him with current pending charges. That is, we can impeach any witness with current pending charges. So that's one method. Another method would be to bring it in through extrinsic evidence. So that would be another method. Depending, and again, it depends a lot on what the state's case is. We don't know what the state's case is going to be as far as Mr. Dukes. They may decide not to present a single word that Mr. Dukes says. We don't know. And we don't have the right to know that at this point. But these are things that we're just asking for you not to foreclose us from being able to present, because if the state brings Bo into this, then we have the right to counter that. Thank you, Judge.
Anything further? Thank you. All right, Ms. Hart.
Your Honor, citing to Moss v. State, it's a 2016 case, 298 Georgia 613. It is a murder case. And specifically there, the defense wanted to bring in, to ask the lead officer about the fact that the victim had been shot previously. And I believe in this particular case, the trial court did not allow that. And in reviewing that, the Supreme Court talked about that a witness may be cross-examined on any matter relevant to any issue in the proceeding. The right of thorough and sifting cross-examination shall belong to every party as to the witnesses called against the party.
Sure.
And then it quotes another case that says that they're entitled to introduce relevant and admissible testimony tending to show that another person committed the crime for which the defendant is tried. However, the proffered evidence must raise a reasonable inference of the defendant's innocence and must directly connect the other person with the corpus delicti or show that the other person has recently committed a crime of the same or similar nature. The defendant in this case is charged with murder, burglary, concealing a death. He is not in any way charged with rape, kidnapping, false imprisonment. He's not charged with any of those things in this case. The only similarity between these cases is that there are female victims. That's it. There's nothing similar about the charges pending against Bo Dukes related to the charges that are pending against this defendant. Nor does the fact that Bo Dukes has committed or possibly committed violent crimes against women take away from whether or not this defendant murdered Tara Grinstead. And so while certainly they are entitled to a thorough and sifting cross-examination if we call Bo Dukes to the stand, that does not mean everything. And every case you read says that there's a limitation. And yes, our rules are absolutely rules of inclusion, but let's be clear, we all know that there are things that don't go in front of a jury. Defense counsel says they want everything in front of the jury. Well, let's be clear, they want everything that's not incriminatory against their client in front of the jury, because there are certainly things that are in this case file that we will not be able to present in front of the jury because our rules exclude them. In this case, Judge, as it relates to the pending...
What is the site of your Moss case again?
298 Georgia 613.
Thank you.
And again, the reason I say if we are the ones that call Bo Dukes, because at this point, Judge, we are still discussing strategy. It's our position that we can prove this case against the defendant without putting Bo Dukes on the stand, mostly because he confessed. So the idea that the only reason we're sitting here is because Bo Dukes gave the defendant's name is not accurate. This defendant was not arrested for the murder of Tara Grinstead until he confessed to the murder of Tara Grinstead. Certainly, Bo's statement to other people that got back to GBI assisted in the investigation, but there was no warrants for this defendant, Mr. Dukes' arrest, until Ryan Dukes' arrest, until he confessed. And so the idea that the only evidence that we have is Bo Dukes is just simply not true. There is his statement, there's other physical evidence, there are statements of co-conspirators, there are statements that this defendant and Bo made together within a week or so of the crime, admitting that the defendant killed her and that they later burned her body. There is ample evidence without Bo Dukes' testimony. The biggest thing here, judges, they want to argue propensity. They want to argue that because Bo Dukes is charged with violent crimes involving sex against women in Houston County, that, by the way, are alleged to have occurred in 2017, which is 12 years after the murder of Tara Grinstead, that he's actually the bad guy, not this defendant. That is exactly what our rules don't allow. And as it relates to whether or not they can prove it by extrinsic evidence, again, I would cite the court in 608, which says exactly that extrinsic evidence cannot be used. If Bo were to testify, the question is whether or not they can ask him if he likes us better than them. Again, that would come into whether or not we call him or they call him, but I think it's pretty clear Bo doesn't like either side. I mean, Mr. Rigby and I tried him and got him sent to prison for 25 years. He's not big fans of ours. So the idea that he somehow is trying to favor good sentiment with us because of Houston County charges is not true. I would point out the court's question about whether or not they intend to call the witnesses. I would submit to the court that the reason that question was not answered, because at least as it relates to the second in time first indictment, my understanding is that even law enforcement in that case have had trouble locating those victims when they attempted to get the victims to come back 2 days later. And again, I've done this job a long time, that happens, but the truth is I don't believe they would be able to have any witnesses that would come in and say that Bo Dukes raped them or committed any sexual acts. They just simply want to be able to ask Bo about it, again, for propensity purposes. And so we would ask the court to disallow it for those reasons.
Do you want to file a response to their motion?
Frankly, Judge, because of my trial schedule, I would be asking the court to allow me several weeks to get it done, and I don't think that that's fair to anybody, so I'll stand on my argument.
I'm going to study your brief and review the Moss and some other cases I can find, okay?
I have an answer to your question from earlier. Lovely, my trusty law partner who's not here sent me the answer to your question. Rule 24-6-611C provides that we always have a right to call an adverse witness, so we definitely have the right to call Bo Dukes, and that we have the right to cross-examine him. And specifically, the state cannot, if the state doesn't want this bad evidence to come out, they can't avoid it just by not calling Bo Dukes. We have the right to call him, and we have the right to cross-examine him and present this evidence, Judge. 611 subsection C, Judge.
Thank you.
Thank you.
All right, Jackson-Denno hearing, that's on here?
Judge, it's a Jackson-Denno issue, not a Jackson-Denno
That's
hearing
the point.
necessarily.
Yeah. Okay.
But I am prepared to handle that if Your Honor wants taking up that issue.
Is there a motion? Did you just hold up a motion? Because I haven't seen anything from the state on Jackson-Denno.
No.
Okay, so I just wasn't sure. I wanted to make sure I was.
No, I don't have any separate writing.
Okay.
All right.
Thank you.
I don't hear from-
Judge, I apologize, I didn't interrupt you.
No, I was just here for.
As Your Honor is aware, back, and I've forgotten the exact date, but back in, I believe, September of 2018, we were here for a number of hearings. They were referenced earlier. At that time, the day prior to that, defense had requested a continuance on the Jackson-Denno motion. The court denied that via, I think we had a phone conference, the court denied it. That morning, when the case was called for a Jackson-Denno hearing and we had our witness present and prepared to proceed, defense counsel again asked for a continuance. I do have a copy of that portion of the transcript as well for the court, so you don't have to sift through the entire transcript. When the court again denied their motion to continue because it had been set for Jackson-Denno for some time, defense counsel then withdrew their motion that they had filed, or I should say, the motion itself had actually been filed by the prior defense counsel. As it was addressed earlier in the testimony of Mr. Rigby, however, the court is aware that simply withdrawing a motion for a Jackson-Denno doesn't satisfy the requirements of Jackson-Denno. We're required as the state, it's incumbent upon us to make sure that before the jury hears any statements or confessions that the court has made a ruling that they're admissible under the law. And so we then, later on in the day, took up those specific issues. And again, I do have a copy of the relevant portions of the transcript.
What page numbers are you
So
using?
the first part is page 11. And then after that, it moves to page 29. So it's page 11, 12, and then starts on 29.
All right, Ms. Person, Judge, we will be withdrawing the Jackson-Denno hearing and not challenging the voluntariness of the statement then based on that ruling. All right, I don't know if the court wants me to go into details right now or wait till we're done, but there are multiple levels to the statement. Some were done at the police department, some were done elsewhere. Given that, I think we need to address specifically what we're talking about that's admissible. And I think we can take that up after we finish going through the list. So then we jump over to page
29, Judge.
Okay. All right. What?
So we begin at the bottom. It's line 24, where I had asked the court to go ahead and let us take up the Jackson-Denno issue. 30 is where you get to the meat of it. I specifically put on the record the fact, as you just read, there is a statement that is taken at the police department. Part of that is audio recorded. Part of it is also video and audio recorded. A small, maybe 5-minute portion of that interview is prior to Miranda. The rest of it is post Miranda. The defendant then agreed to go out to the site in Fitzgerald or in Ben Hill County with law enforcement to point out the place where he believed he had burned Ms. Grinstead's body. And that is also video recorded. There's a video recording of the defendant while he's out there. And so all of that occurs on the same day within a short period of time.
The specific point, I guess, is on line 24, page 30. I just want to make sure when defense counsel is saying she is withdrawing her objection as to voluntariness of the statement, that we're including both the pre-Miranda and the post-Miranda, statements.
Correct.
Ms. Merchant, we are, Judge. Okay, we're withdrawing our objection.
And then later on,
Right.
I apologize.
No,
but
go ahead.
I specifically reference that they are agreeing that in addition to voluntariness, they're indicating there are no Miranda violations, that there's no hope of benefit or remotest fear of injury that was given. Ms. Merchant says, yes, Judge. Your Honor then says, on all issues then, and Ms. Merchant says, Jackson-Denno issues, the court, all Jackson-Denno issues, Ms. Merchant, yes, correct. And then at that point, Your Honor asked me to prepare an order.
Seems like you did.
I did prepare an order, and sorry.
She said it, and the Merchants objected to it, or Mr. Gibbs, there was some objection to the written order, wasn't there?
I don't believe Mr. Gibbs is on the case yet,
Okay.
but when I sent it to Mr. and Ms. Merchant, they were not in agreement as to that particular order. I never received any response as to what needed to be taken out of the order. They just continued to indicate, well, we just withdrew our motion. We're not stipulating to all of these Jackson-Denno issues. And so we're here today asking the court to enter an order, whether it is the content of the order is consented to by defense counsel or not.
Sure.
I have drafted a proposed order for the court based on what Your Honor just read from the transcript, and I will allow defense counsel to take a look at that. But we're asking the court to go ahead and enter an order, not just the fact that they've withdrawn their motion for a Jackson-Denno or motion to suppress the statements, but that these statements were voluntary, knowing, and that all of the requirements related to the Jackson-Denno issues and a statement being admissible for a jury have been waived.
You know, the statement, Agent Shadell, at some point, was it the bond hearing that he testified about the statement?
Yes, Your Honor, it wasn't a bond hearing. He testified about the statement.
Okay.
It was never waived. We testified about it.
Well, he spoke about it.
Yes, sir.
Right. Okay.
Thank you, Judge. First of all, is this my copy you just handed me?
It can be your copy. I think I have another one.
Okay.
I'll print it.
Right.
I've never seen this order before, except for 2 minutes ago, so I'd like a chance to read it. The state did prepare a draft order. It was in rich text format, which when you open it in a Word program comes up very odd, and so I wrote the state back. I've written them back 4 different times asking for it in Word so that we could put our changes in that, so it could be track changes, because you can't track changes in rich text format. You can't edit that in a Word version, and we've received no response from that, so we would have been more than happy to explain all of our objections to it, but I'm more than happy to go through those right now. The state sent us an order that has some language that's included that we did not agree to, and we do not agree to. And it looks just from a very quick glance that that's also included in this new order that they've proposed. Specifically, they say that the,
Let me have a copy of that too, please.
Judge, and I apologize, I thought I had multiple copies, so that was my only copy. If I can get just a moment,
Sure.
I can make a copy.
Let's take about a 5-minute recess.
Thank
and
you,
we'll
Judge.
get back. 3 copies, thank you.